Hello, and welcome to Arbitral Insights, a podcast series brought to you by our international arbitration practice lawyers here at Reed Smith. I'm Jose Estigaraga, Global Head of Reed Smith's International Arbitration Practice.
As we close out 2021 and look towards 2022, we are pleased to present this mini-series of podcasts that will review key developments over the past year across a number of important geographic regions, industries, and specialisms, and we'll look ahead to consider what the next 12 months might bring.
I hope you enjoy the industry commentary, insights, and anecdotes we share with you in the course of this series, wherever in the world you are. If you have any questions about any of the topics discussed, please do contact our speakers. And with that, let's get started.
Hello everyone, and welcome back to the latest episode of Arbitral Insights. In this short podcast, members of the Reed Smith's International Arbitration team will look back at some of the key developments in Asia during 2021 and look ahead to 2022. My name is Timothy Cook, and I'm an International Arbitration Partner in the Singapore office of Reed Smith, and with me today is Lianji Li, Head of the Transportation and Commercial Litigation Practice in our Hong Kong office. So in 2021, we saw some important developments, particularly in case law for international arbitration, and we will look at three examples of those, starting with some recent developments with the arrangement for mutual assistance in court-ordered interim measures in aid of arbitration proceedings between China and Hong Kong. And then we'll look at two recent arbitration decisions by the Indian Supreme Court. And after that, we'll turn our gaze to 2022. So let's start with the interim measures arrangement between China and Hong Kong. The arrangement was introduced in 2019 and by all accounts has proven to be an extremely useful tool for parties engaged in proceedings looking to enforce interim orders. Could you explain how this arrangement works?
Hi, Tim. It is my great pleasure to have this podcast with you. And on 2nd April 2019, as you said, Hong Kong Special Administrative Region and the Supreme People's Court of PRC signed an arrangement concerning mutual assistance in court-ordered interim measures in support of arbitration proceedings by the courts of mainland China and Hong Kong. And this came into effect on 1st October 2019. Hong Kong became the first jurisdiction outside mainland China. The parties would be able to apply to the mainland courts for interim measures before the arbitration award is made. So parties to arbitration which are seated in Hong Kong and administered by a recognized arbitration institution can apply to the mainland Chinese courts for interim measures, and those including property preservation, evidence and conduct preservation. And similarly, Hong Kong can apply similar measures to the mainland arbitration institutions. We have had experience to make application in mainland China, and a quite easy standard procedure to be followed. Basically, you apply one of the arbitration institutions, if you have chosen in the arbitration agreement, for a letter of confirmation of the acceptance of the case. Then you file the application in mainland Chinese courts. Of course, the standard requirement in China includes the counter-security for wrongful attachment. The counter-security will depend on the claim amount, and the bond, insurance company can issue bond for the security. And as of 18 November 2020, Hong Kong International Arbitration Center has issued the letters of acceptance in respect of 56 applications, and the total value of the assets have been reserved amount to RMB 14.8 million. And in the mainland Chinese courts, they have received 40 applications. 37 have been granted with a value of RMB 12.4 billion. So this makes Hong Kong in a very good position in terms of pre-arbitration award attachment. It's practically good for the Hong Kong arbitration conducted in Hong Kong. Thank you, Tim. That is brief to introduce how it works.
It's very interesting how this has been introduced, and it seems as though it's proven to be a very successful and practical measure, as you said, to sort of assist with these sorts of pre-attachment proceedings, which are often such a practically important step in arbitration. Sometimes if you don't get that early pre-attachment, it can cause great difficulties, or even question whether you should and how you should proceed with your arbitration if you don't get it. So I can see that that's enormously attractive to people, particularly when they're investing or have investments in China.
Yes.
I guess in a similar sense, or similar in that we're talking about interim measures, I was going to mention a couple of cases that have arisen in India recently, one of which does concern emergency arbitration. And it's quite a well-known case of Amazon.com, End Investment Holding, and Future Retail. And this, I think, is another decision which, similar to that arrangement that's now been in place in China and Hong Kong for a few years. This decision, I think, it's a sort of pro-arbitration and positive development in that it gives a lot of comfort, I think, to parties who have chosen to arbitrate but sometimes need to go to court to get additional remedies. So in this case, this Amazon and Future Retail case, I can just summarise what happened. The parties had entered into a shareholders' agreement, and one of the terms of that agreement was that Amazon had the right to consent to certain transfers of assets by Future Retail to restricted persons. And then what happened about a year later after signing the agreement, Future Retail then sought to dispose of assets to one of those restricted persons, which Amazon didn't consent to. So Amazon sought to injunct the completion of the sale by way of an emergency arbitration. And the emergency arbitrator found in Amazon's favour, and Amazon then took the emergency arbitration award and sought to enforce it in the High Court of Delhi. Now, at first instance, the court made that order of enforcement, but it was subsequently stayed, and so the matter was quickly escalated up to the Supreme Court. And a number of issues came on for determination, and the court made a number of findings. But I think most importantly, what it confirmed was that an award rendered by an emergency arbitrator in an Indian-seated arbitration is enforceable in the Indian courts. And now that in itself provides, I think, welcome clarity for parties looking for urgent interim protection in those sorts of arbitrations. But it also sits on the back, I think, of a trend of pro-arbitration decisions that we've been seeing coming out of the Indian courts. It's not just 2021. I think you look back over the last few years, you've seen a growing body of jurisprudence from the Indian courts which are pro-arbitration. And one of the things that certainly struck me from reading the decision was one of the justifications that the court gave for emergency arbitration was from a policy perspective, effectively saying that these sorts of decisions are enforceable, and they, by going through an emergency arbitration route, they reduce the strain on the domestic courts for having to deal with those sorts of applications. And it did strike me that it's rather similar to comments that were made many years ago in the mid-1990s in relation to Singapore's arbitration laws, and when Singapore was looking and took a decision to develop itself as an arbitration hub. Hard to believe now, but in that time the courts were facing serious delays, there were backlogs of civil litigation, and arbitration was put forward as one way to help alleviate that sort of pressure on the court. So it's interesting that India, which I think has in the past had some reputation for having such a backlog of commercial cases in its courts, it's interesting to see the Supreme Court coming up with similar sorts of reasoning, promoting emergency arbitration. So that's what I was going to say about the Amazon case. That there is a second decision, also part, I think, of a growing trend, another Indian court decision, which reveals a positive pro-arbitration position. And it's the case of PASL Wind Solutions and GE Power Conversion. And the interest in this case is to do with Indian parties that contract with each other. What are the circumstances, or is it permissible for those two domestic Indian companies to arbitrate in a foreign seat? And there had been some uncertainty as to whether this was permissible or not. But in this decision, the Supreme Court upheld that domestic Indian companies can arbitrate a foreign seat. Now, on the one hand, you may think, well, that's not terribly interesting unless I have a company based in India. But the significance of it is really when you look at international companies who are establishing subsidiaries in India for the purpose of transacting business with domestic corporates. And often those are the parties which would then negotiate arbitration in a foreign seat, especially Singapore or London. And so this decision is a very welcome decision. I'm sure it provides comfort and certainty for parties and international investors who are interested in investing into India. So I think those are, just a small number of cases or examples of what's happened in 2021. I thought what we could do is turn our minds to 2022 and what might be in store for us. And I think if I were to say anything, it would be that there's going to be a continuation and I think a likely acceleration of acceptance and supportive measures for arbitration in the sorts of examples that you mentioned, Yanji, and in these cases. I think we're going to see more of those sorts of cases being decided, but it's not just judge-made law. We've seen, for example, legislative changes as well. So Singapore has recently made some tweaks and changes to its International Arbitration Act, all very much, with the idea of continuing to promote arbitration seated here. And this idea of harnessing law to support the development of the seat is something I think that Hong Kong and Singapore have done with great success. And as I understand it, China is now looking to introduce a new arbitration law. And Yanjin, I was wondering if you could tell us a little bit more about what that law may contain.
Yes, the arbitration law of the PRC has remained substantially unchanged since its enactment in 1994. On 30 July 2021 this year, the PRC government has released its proposed revisions to the current arbitration law for public consultation. So the draft proposal, including mainly the following aspects. One is to establish the seat of arbitration standard. So in the past, the nationality of an arbitration award has been determined based on the place where the arbitration institution was located. However, the judicial practice of this approach has caused uncertainty and confusion. For example, a Chinese court has held that an ICC award rendered in Singapore was a Singapore award rather than a French award. In another case, a court in Guangzhou held that an ICC award made in Guangzhou was a Chinese foreign-related award. Therefore, the draft proposal formally recognized the concept of the legal seat of arbitration. So that is one of the developments. Secondly, the draft includes the powers to be given to the arbitration tribunals to order interim measures. In the past, only the courts have such power. Thirdly, it clearly provides the tribunal's competence to decide its own jurisdiction. So the current law only permits the arbitration institution to decide the jurisdiction of the particular institution or the tribunal. Lastly, ad hoc arbitration would be recognized in certain circumstances. In the current law, only the institution arbitrations will be recognized. So those are the developments and for the draft proposal. Hopefully, the legislation will be passed soon.
Well, there are some major changes there. I mean, particularly in relation to the last two you mentioned, which I'm sure are going to be, very attractive for people when they are choosing where to seek arbitrations. And I think one of the things that's interesting, here in Asia is that we've seen such a growth in the popularity of arbitrating in Asia, and to some extent that's been led by Hong Kong, which has traditionally been such a popular venue, but then more recently with Singapore as well. But now you're seeing with this sort of change that you mentioned, these sorts of legislative changes, a sort of halo effect of other countries also becoming more aware of the importance of arbitration and embracing it. It's not to say, of course, that China hasn't embraced it for very many years. Of course, it has probably more arbitral institutions and more arbitrations than anywhere in the world, probably. But this sort of change is such a positive affirmation and sort of confirmation of arbitration that it's going to be very interesting to see how that affects people's choice of CETAN and maybe even rules as well. I think of the likes of CTAC, they will become increasingly an attractive option with this sort of legislative support. So, that's sort of legislative change. I think the other thing that we're likely to see is continuing updates of institutional rules. In years gone by, institutional rules were changed, fairly long intervals, but more and more institutions are much more responsive to changes. I think an obvious example has been the pandemic, and in the last 2 years, there have been a huge number of changes to institutional rules that have all updated their rules to make explicit that, for example, virtual hearings are supported. And one institution I think is worth mentioning, partly because Nanjun, you and I have sat on the committee that's looked at this, but is the Singapore Chamber of Maritime Arbitration has published its new rules this month, providing a substantial refresh to incorporate sort of a range of different features, those to streamline the proceedings, promoting sort of cost-effective measures, such as dispensing with the requirement for an oral hearing, which was in the old rules, increasing the value threshold that's required for parties to use the expedited procedure, and of course things surrounding virtual hearings. So I think the SCMA refresh is a good example of the sorts of refreshes we've seen elsewhere, and I'm sure that in next year we're going to see more of those sorts of refreshes. I know the SIAC is looking at amending its rules, so that'll be one set of rules I'm sure will have its new edition being published in 2022. I was going to just, again, with my gazing into my crystal ball, was going to say that I think another thing that's going to happen in the next year is an increasing awareness and increasing engagement of other arbitral institutions in the region. As I said, I think the SIC, HKIC, and CTAC have been fairly dominant in recent years, but now I think we're starting to see other institutions like the AIAC in Malaysia, THAC in Thailand, even Barney, Indonesia, the VIAC in Vietnam. These are all institutions which I think have now tuned into attracting international parties to arbitrate at their institutions. And I think that's something we're going to see, not necessarily just in the span of 12 months, but I think this year is going to be part of an accelerated interest and in those institutions. And sort of on that subject, I understand that there are a number of institutions in the China Greater Bay Area which have recently signed a cooperation agreement to promote arbitration. And I was wondering again, Nanjun, could you explain a bit more about this and how do you think it might affect maritime trade in this area?
Yes, I would like to introduce Great Bay Area concept for those who are not familiar with this. Now, the Great Bay Area in China may play a very important role in the consolidation for arbitration across the Asian Pacific. The Great Bay Area in China comprises of two Chinese special administrative regions including Hong Kong and Macau, and also 9 cities in Guangdong province. And in this regard, the integration of the Hong Kong legal service into PRC's development course would enhance the consolidation of international legal and dispute services across the Asia-Pacific region. So in Greater Bay Areas, we have population of 86 million, and the GDP for last year is US dollar 1,066.8 billion. Hong Kong is the only common law jurisdiction within China that makes it stand out from other arbitration venues in China. As you know, most Chinese foreign-related parties, they do prefer common law jurisdiction, and Hong Kong is the only place in China with common law jurisdiction, where the courts have a very pro-arbitration attitude. In terms of the talent, the first examination for Hong Kong lawyers to practice law in GBA, Greater Bay Areas, was held this year on 31st July 2020 to allow Hong Kong lawyers to deal with both civil and commercial legal matters in the 9 mainland Chinese cities in GBA. Recently, in Shenzhen, Qianhai areas, most notable arbitration institutions are allowed to operate there, to have the arbitration there. So that is another development. Last month, a memorandum of understanding on promoting maritime arbitration in the Great Bay Area was signed among 5 leading arbitration institutions in this area, including CTEC Hong Kong, CMAC Hong Kong, Hong Kong Maritime Arbitration Group, Guangzhou Arbitration Course of International Shipping, and Maritime Arbitration Center of the Shenzhen Court of International Arbitration. So under this MOU, the parties agree to exchange information on information relating to maritime arbitration. So the Great Bay Area will definitely affect or influence, give impact on the Chinese maritime legal and arbitration services, and more institutions to cooperate or collaborate in promoting arbitration. And particularly in Shenzhen, as I said, many international arbitration institutions have their offices now.
Well, it sounds again like there's a huge opportunity, and I don't know how long it will take for that sort of project to bear fruit. But you can see that I'd have thought at least we'll see the start of that in the coming months. We'll have to see maybe in a year's time what progress has been made. So, wrapping up all these points then, it seems to me that 2022 will be a year of steady consolidation for arbitration across Asia-Pacific. I think that's all we have time for today, so it remains for me to thank you, Lenji, for sharing your thoughts today.
Thank you, Tim.
And thank you for listening to this Asia-focused episode in Reed Smith's International Arbitration Horizon Scanning Series. Thank you.
Arbitral Insights is a Reed Smith production. Our producer is Ali McCardle. For more information about Reed Smith's global international arbitration practice, email Jose Estigaraga at jia@reedsmith.com. You can find our podcast on Spotify, Apple, Google Play, Stitcher, reedsmith.com, and our social media accounts at Reed Smith LLP on LinkedIn, Facebook, and Twitter. This podcast is provided for educational purposes. It does not constitute legal advice and is not intended to establish an attorney-client relationship, nor is it intended to suggest or establish standards of care applicable to particular lawyers in any given situation. Prior results do not guarantee a similar outcome. Any views, opinions, or comments made by any external guest speaker are not to be attributed to Reed Smith LLP or its individual lawyers. All rights reserved.